LIEnette and John CROOK, my horrific neighbors, have gotten themselves in a heap of trouble, a whole trash load of trouble, in federal court. With my legal counsel, I have filed for a writ of prohibition, or in other words, I'm asking the courts to remove Judge DeThomasis from the hearings in the Levy County Courthouse for good, forever, and replace him with another judge. Now, the other thing that we can do, since DeThomasis put such a ridiculous amount of time, such a short amount of time to where we could actually file the writ of prohibition, we can amend that writ of prohibition, which we have done. Now, since that day, LIEnette and CROOK have gotten themselves in quite a bit of legal trouble. There's more in Ohio, there's more in federal court, and we're still at that stay, or everything is on pause or at hold in the Levy County Courthouse. Now, we've sent an amended, a 58-page amended writ of prohibition to the appellate courts as they review everything with Judge Grudge DeThomasis, who says, "Mark Feather!" who I think is an amazing individual. So I'm going to go through some of this with you because I think it's very, very important. And it's extremely satisfying to understand where this case is all headed. Let's dig right in. Although this petition comes before the court on matters involving disqualification, I'm reading to you right from here. Although this petition comes before this court on matters involving disqualification of a judge for bias, that would be Judge Craig DeThomasis, the underlying issue concerning an injunction petition filed by Preston, LIEnette, under Florida cyberstalking statute, section 784.0485, Florida statute, and Hale's First Amendment rights to engage in constitutionally protected speech. Remember, I have never, ever crossed the line. I have always been on the side of constitutionally protected speech. Now, LIEnette and CROOK have crossed that line, and others in their following or their support groups have beyond crossed that line. In other words, they have committed crimes. So, constitutionally protected speech on his popular YouTube program called What the Hales. Do you think maybe some of these individuals in the appellate courts are watching What the Hales yet?
Maybe.
Maybe. We don't know. It's broadcast from his home in Ohio. Emphasis on my home in Ohio. Remember, it was LIEnette that has complained, stating that I can't run for mayor. I can't run for Otter Creek Council. Why? Because I'm not a full-time resident of Otter Creek. She's complained over and over again that the things that she says I want to do in Otter Creek, I can't because I'm not a full-time resident. And then she gets to a federal case and states, hey, he's a full-time resident. No, I broadcast from my home in Ohio and my vacation home in Otter Creek, Florida, where the Hales, that would be me, lives for several months a year, and the show has a national and international interest with a subscription of over 700,000 people. What the Hales is a video journal. It is vlogging, video logging of my life. And this is what we tell the appellate courts as well in this writ of prohibition. What the Hales is a video journal of Hales' life, and with interest generated in their treasure hunting experiences. And let's see, we got entertaining, philanthropic. We do a little bit of that. We love to help people. And we love to hold events that can help people. So we do a lot of that. Promotional events filled with local color, often involving extensive charitable giving. And Preston, LIEnette, was a fan turned stalker who moved from the Sarasota area, which is Northport, to live right next door to Hales in Otter Creek. In mid-2023, Hales and George obtained a permanent injunction against Preston for stalking from his Ohio home-based court. And yet, LIEnette wants to say that, George, we're not residents of Ohio? I mean, how did she get so smart? How did she get away with this? You know, every time I have to read anything or be involved with anything in LIEnette and John, I just sit there and think, anybody, please, just anybody.
Please won't you be my neighbor?
Instead of them, please, instead of them. Anybody at all, just not them. And as we go on, Preston then sought a similar injunction against Hales in Levy County, Florida, where the case is still ongoing, and the presiding judge is Craig DeThomasis. Now, I want to make it very clear, September 3rd in a live stream, George and I announced that we had already given a retainer, hired a lawyer to move forward with civil protection orders in Ohio. Now, that doesn't mean that we go to the court the next day. It means we go on their timing and when they can go to the court with us. Once LIEnette understood that, once LIEnette heard that, then she ran to the Florida Levy County Courts to try and get an injunction, which she was told multiple times there is no evidence whatsoever. And even when we got into a hearing, she was told there was no evidence. And it wasn't until she filed a supplemental piece of paper stating that Mark Feather bribed her, and yet under oath she said, oh, he was trying to talk about the story changes so many times, it's ridiculous. I can't even keep up with it. But the reality is there was no temporary injunction. There was nothing in Florida until she further went on and lied more. So this petition or writ of prohibition arises from the trial court's recent denial of 2 motions, not 1, 2, which this would also be the 3, to disqualify Judge DeThomasis for bias filed in quick succession. On February 11, 2024, Hales served his second motion to disqualify based on the events of a hearing of January 23, 2024. And on February 14th, the judge denied the motion in a 5-page, single-spaced order, which included the following language. And I'm sure at this point in time, if you've been following this story, the judge cannot defend his decision to not remove himself. He just has to say no. He says yes or he says no. It's that easy. Denied or approved. All right. So this is what he says. This is just a portion. And he goes way out of his legal bounds in saying this. Judge Grudge says, it is true that on January 23rd, 2024, this court did make an oral pronouncements that were adverse to the positions being advanced by the respondent through his counsel regarding the posture of the case and the intervened developments, some contrary to law, that again participated in another request for continuance. You know, normal people don't use these kind of big words. You know, LIEnette can't understand it. These included, but were not limited to, the following on the record proceedings. Again, he's already gone way past his authority in what he can say. A, on 11/29/23, in response to the court inquiring whether he, the respondent, meaning Jeremy Hales, would be available to reconvene the following date at 9 a.m. to complete the hearing, co-counsel for the respondent, Mark Feather, represented the court the following: no, Your Honor, Mr. Hales is having to address matters in Ohio court related to this situation. Make sure you understand that. No, Your Honor, Mr. Hales is having to address matters in Ohio court related to this situation. He did not say there's a hearing. He did not say that there's a contempt of court hearing that LIEnette's going to be involved in as well. He said Jeremy has to go home to Ohio to address matters with the Ohio court. That's it.
He also said he had a flight out.
All right. So DeThomasis gets that right. And he says he has to be there tomorrow morning, which I did. I had a flight. I had to be at the Tampa airport at 9 a.m. to get my flight. It's not like I can just cancel my flight and then get another flight to go do the things that I need to do, right? So let's move on. Let's move on. And so based on such representation, the court continued the matter, which at the time did not have any temporary injunction relief in place, to reconvene on 12/6/23, which he did do a continuance, not based on me. The continuance was not based on me. The continuance was granted because the courts were closing and LIEnette was still rambling with her word salad, going on and on and on and saying absolutely nothing. And there was still no evidence for a temporary injunction based on DeThomas's own words. All right. B, during the proceeding held on 12/26/23, the court learned from co-counsel Randy Shockett and the respondent himself on the record that the respondent did not actually need to appear in Ohio court on 11/30/23. Now, let me make it extremely clear. I never said I had to appear in court. My lawyer said on behalf of me, I had to go take care of matters with the Ohio court. All right, and he only needed to sign documents 2 days later with his Ohio attorney. As a direct result, it is true alleged in the motion under review that the court did admonish counsel for lack of candor towards this tribunal, and such behavior was again addressed in 123-24. The court considered the totality of circumstances in the case when deliberating on additional motions being adjudicated. In other words, what DeThomasis is saying is, you dirty liar, you're a dirty rat, I'm gonna get ya, I'm gonna get ya. Nobody lied to him. He misrepresented what was told to him. And everything happened so quickly, as it was anyway, as the judge, DeThomasis, was trying to close down the court, not because he had control of his courtroom, not because he kept LIEnette to a relevancy of what should have been discussed in the courtroom, because he let it get completely and totally out of control. I had a flight the next morning. I'm not canceling that flight. I'm not coming back in at 9 a.m. because of LIEnette's word verbiage and lack of it. And she, it's funny. I have a plane. That woman doesn't know how to land a plane. It just keeps going on and on and on. C, further, despite the clear dictates for the Florida Supreme Court and administrative order, blah, 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 he cites case law, there was undisputed evidence that confirmed attorney for the respondent, Mark Feather, despite having previously signed a piece of paper that he was aware they admonished regarding the prohibition against dissemination of unredacted copies of court proceedings, did disseminate an unredacted copy of the 11/29/23 court proceedings, as he was the only person to have requested an unredacted copy of his client. The respondent then broadcasted the unredacted copy on his social media platform. Let's just stop right there, okay? So yes, Mark Feather requested the video hearing, and I requested it from Mark Feather, and then I posted it on YouTube. And it doesn't matter whether it was redacted or unredacted. It's exactly the same. There was no redactions that needed to happen. None whatsoever. But Judge DeThomasis got something stuck up his rear end. It might be crook for all I know. And is still stuck on this redacted, unredacted. It's all the exact same. Nothing was redacted because nothing needed to be redacted. It is true, as alleged in the motion under the review, that counsel was admonished on 123 for such behavior, as it was contrary to the dictates of the Florida Supreme Court. And it goes on, the chief judge in the 8th Judicial Circuit, remainder of the paragraph omitted. D, it's true on 123-24 that the court did express dissatisfaction and admonish counsel for the respondent for broadcasting unredacted audio and video, which, by the way, again, is still same as redacted, exact same, of the court proceedings, despite the clear dictates of the Chief Justice of the Florida Supreme Court and the Chief Judge of the 8th Judicial Circuit. Which, again, it's all the exact same. So Judge DeThomasis is upset because I released unredacted video, which again is the exact same as redacted video. E, further on 123-24. Remember, this is everything that DeThomasis wrote in his denial of the dismissal of the motion that was filed to dismiss him. E, further on 123-24, the court also learned that the attorney Randall Shockett conducted a video deposition of the petitioner, that'd be LIEnette, without complying with the Florida Rules of Civil Procedure 12.310B4, which, by the way, he did everything in regards to the actual statute and the rules. But that'll be cleared up here later. And despite having conducted said deposition in the contravention of the applicable rule, the respondent had published and publicly broadcasted said deposition on his social media site. It's true that the court expressed dissatisfaction with such a violation and denied counsel's ability to play the video deposition, which was taken in noncompliance with the rules of civil procedure. By the way, he did deny my lawyer playing anything with the deposition in court. Now that he can't do. And I own the video. I paid for it. And all of this is public information. We are in the Sunshine State. We are under Florida Sunshine Law. Public information. Emphasis on the public. You know, like the supermarket that all Floridians love to go to. Public. Although LIEnette probably spells it with an X, it's actually spelled with a C when it's information. F, it's true as alleged in the motion under review on that 1/23/24 that the court also commented upon a proffered memorandum of law that was presented to the court by Attorney Randall Shockett, submitted on 1/22/24. See docket entry 97, that in the court's view, unnecessarily, unprofessionally, gratuitously criticized opposing counsel for filing a limited notice of appearance on the purpose of advancing an argument to continue on behalf of the petitioner. In other words, what Judge Grudge is saying, I'll let LIEnette's lawyer, Silver Scam, do whatever he wants. But if Jeremy's lawyers, Feather or Shockett, do something, I'm going to admonish them in court. That's basically what this is saying. This is 100% pure bias. All right, but let's keep going. And as counsel adverred, he had conflict and could not and would not be able to serve the counsel in the event that the court did not change the next scheduled hearing date from 1/26/24 date previously scheduled. As the record would indicate, the court did admonish respondent's counsel. I mean, everything that comes out of DeThomas's mouth towards my sign is admonishing my lawyers. I don't get it. And he's not said one thing to Silver Scam, his good buddy. And for presenting such an argument and in such a manner as the court also remarked it and reminded Mr. Shockett that he, Mr. Shockett, filed his own notice of appearance 24 hours prior to an already scheduled argument that he could not possibly be prepared for and required and needed a continuance, which was granted. By the way, Mr. Shockett, he had to come and be my legal counsel because LIEnette lied about Feather, and now Feather is a witness. So this all happened because of LIEnette. This didn't happen because I wanted to go and find another lawyer. This happened because of LIEnette's lies. Oh, but you don't see DeThomasis saying anything about that, do you? The rhetoric and condescending language advanced in the filing labeled as a memorandum of law and which described as wholly unacceptable behavior of the opposing counsel was in fact the same behavior previously exhibited by the respondent's counsel. I do not agree at all with Judge Craig DeThomasis. And the only thing I agree with him on is nothing. Absolutely nothing. As a matter of fact, when he runs for judge again, I am going to make videos telling the truth about him, about all the creeps that he has written letters for of recommendation. He literally, his good buddy is a voyeur in a tanning salon, takes his cell phone, puts it over, and he's filming unclothed women. You think that's okay? And he's telling the system, it's okay, he can still be a lawyer. He's going to be a better lawyer because of this. I don't see Craig DeThomasis saying, it's okay, Jeremy's going to be a better YouTuber because of this. Or Feather is going to be a better lawyer because of this. Shockett's going to be a better lawyer because of this. I can guarantee you I'm going to do everything I can to make sure this man never sits on this bench again. This is so inappropriate, so wrong. But let's keep going. Number 8, as stated, remember, this is everything that Judge DeThomasis said in his denial of my motion to remove him. And he goes on to say, number 8, as stated above, adverse rulings and or even a series of adverse rulings are legally insufficient grounds for disqualification. In other words, he's saying, you can't disqualify me. Further, as the case proceeds in the trial court, it's the court's responsibility to assure the orderly administration of justice. Orderly administration of justice? When have you seen Judge DeThomasis actually have an orderly courtroom? I'll wait. Anybody? Has he had control over LIEnette? No, we all know that. And the fair application of law to assure counsel's adherence to regulations of the bar as well as a code of professional conduct in the dealings with the court personnel, opposing counsel. It's necessary and an obligation of the court to question counsel regarding behaviors affecting the administration of justice and to place on the record the specific critical concerns of the court, as was done in each of the prior hearings, and allow the response of counsel, if any, concerning any of the transgressions. You know, another word for transgression is sin. So Judge Grudge is now saying that my lawyers are sinning in court. Go figure. This is a Greek with a temper, no doubt about it. And or violations of law. Now he's saying that they broke the law. Or there's standards of conduct that directly affect the legal process in the case to be adjudicated by the court. Wow, he has some extremely strong language. And the funny thing is he's saying, as we already touched base before, that my lawyer's language was too strong. And yet he's coming out with all of this strong language. Number 9, any objective review of the proceedings held on 1/23/24 would not cause a reasonably prudent person to fear not receiving a fair trial. Do you understand? This man right here in this is stating that any normal person would not fear getting a fair trial from him. This in itself shows his bias when this prudent person is stating, I'm not getting a fair trial by any stretch of the imagination. I don't think anybody has even watched these videos is convinced that I could get a fair trial. Now, the judge in Ohio, that's a fair judge. Puts me in my place, puts LIEnette in her place. No matter what, she's fair. She keeps order in the courtroom. DeThomasis, anything but. All right, so to grant disqualification on the basis of the manners averred in the motion under review, which consist of confronting counsel with their unacceptable behaviors and actions contrary to the law, would be tantamount to allowing attorneys and litigants to violate rules promulgated by the Florida Supreme Court, orders issued by the Chief Justice of the Florida Supreme Court, orders by the Chief Justice of the 8th Judicial Circuit, and to surrender and abandon all precepts of the regulated practice of law. And if they are then called upon to account for such behaviors and or to answer or explain such behaviors, they are admonished for doing so. They should be allowed a fresh start with a successor judge. He's saying, talk to the hand. That's what he's saying. He's saying, I am not giving you a new judge in this case. And then it goes on 8A or 9A regarding the adverb contained in paragraphs 11 and 12. Without addressing the truth of such, it's illogical, irrelevant, and inconsequential to accept competing hypotheses as adverbs that can be attested to by the affidiant. You know what? I don't even know most of the words he's using. You know, it's at this point in time that I'm glad I can use. Here's the thing, okay? I used to speak all over, okay? And I used to teach people how to publicly speak as well. And the thing is people like Judge DeThomasis, they want you to think they're smart. So they use words that nobody uses in everyday life. They use words that you can't spell. They use words that you and I are sitting there going, what? The smartest people are the people that take big concepts and they put it down on the bottom shelf for everybody. For example, we all know E equals, finish it for me, E equals MC squared. What did this genius do? Put it on a bottom shelf for us. E equals MC squared. As I used to teach and preach and speak all over the United States, I would try and take these hard concepts in God's word and try and put it to a point and say, listen, there is one interpretation, but there's many applications that we can get from this. This is how we apply it to our life. Here's this concept. Now, this is how we're going to apply it. We're going to apply it. We're going to apply it. And put it down to a point to where we can apply it and live it every day. Now, as I read all of this from Judge Craig DeThomasis, most of it I can't even understand. And I'm guessing there's a lot of us that can't even understand this. He just wants us to know how smart he is. Okay, great. He's smart. But is he actually doing the right thing? I'd rather know somebody dumb who does the right thing than somebody smart who does the wrong thing. But let's keep going. Claiming competing hypotheses are both concurrent to true, represent pure subject conjecture, legally insufficient to entitle the motivant and the relief. Man, this is just insane. You think I'm making all these words up? Look at this. This is what I'm reading right now. All of this. All right, basically, in a nutshell, what it says, these additional matters are likewise legally insufficient to grant relief requested. He could have just said, no. As a matter of fact, legally, he was supposed to say, no. But he went in with all of this ridiculousness because he wants people to know that he uses big words. I don't get it. The expansiveness of the February 14th order denying disqualification. By the way, this is now myself and my lawyers. The expansiveness of the February 14th order denying disqualifications prompted Hales's third motion to disqualify the judge for bias served on February 21st. Judge Thomas denied that motion in another expansive order on February 28th, and which reiterated his remarks from an earlier order, albeit in summary fashion. The February 14th, I'm trying to say all these big words that Craig DeThomasis has put on these papers, and I can't get it out. Sorry, he's too smart for me. Judge Grudge is way too smart for me. The February 14th and the February 28th orders are collectively referred to as the disqualification orders. Hale served his first disqualification motion on December 21st, 2023, which was denied on December 26th. Those items are included for context. It's attached to this writ of prohibition. And the amended appendix is filled herein with all the documents, including the relevant official transcripts as cited. The argument section contains a pinpoint that cites to the items in the record as well. In other words, my lawyers put everything in here that proves that he is biased. All right. So let's get down to the meat of this. All right. Why are we doing this? Because we're trying to prohibit Judge Craig DeThomasis from participating in this case from here on out. What he has done, in my opinion, is illegal and has overstepped every legal bounds and authority that he's been granted. And now he tries to justify it within legal documents. Why would he do that? Because he sees this as coming. He's trying to justify it as it's going to literally go to a higher court for review. So standard of review, let's see what we say here. Allegations in the motion to disqualify are reviewed as legally sufficient. All right. And you get case law right there. So I hope you got that. Allegations in a motion to disqualify are reviewed as legally sufficient. In other words, DeThomasis has already stated everything Jeremy and his lawyers have said is legally insufficient. The law states that it is sufficient. Simple allegations. The fact that I tell a judge, I don't feel that I'm going to get a fair trial, that is legally sufficient for him to remove himself, yet he's refused 3 times so far. All right, the standard for reviewing the legally sufficiency of a motion to disqualify is whether the facts are alleged, which must be assumed to be true. I've alleged facts. Remember, DeThomasis says that he has to take everything LIEnette says as truth because that's the law. And yet everything I say, he tries to argue against as if he's still a defense attorney. It's insane in all reality. All right, which must be assumed to be true, which would cause the movement to have a well-founded fear that he or she will not receive a fair trial at the hands of the judge. So I hope you grasp the very fact that he keeps fighting and arguing the motion to remove him is the grounds and the foundation to remove him. Now, if he's so smart, which he thinks he is with all these big words, don't you think he knows this is the law? Don't you think he knows that he must remove himself? And yet he continues to refuse. You've got to ask the question, why? Why does this man not do the right thing? Why does this man not remove himself? All right. The excessive disqualification orders are themselves independent basis to grant a writ of prohibition. Again, the fact that he's denied and he has written so much instead of just saying no, that in itself alone is the basis to say, yes, he must be removed. But we're going to get into that just a little bit here because there's a lot of reasons to remove him. So it says when a trial court looks beyond the legal sufficiency of a motion to disqualify for bias or attempts to refute all allegations, it exceeds the proper scope of inquiry and disqualification is required on that basis alone. Now I'm going to show this to you right here. All right. This is what he's done. He's gone outside of the scope of the law and disqualification is required on that basis alone. We could stop right there. And there's case law to prove it as well. We could stop right there. We don't even have to mention anything else. Just based on what he's said and done, he should be gone. But for some reason, he keeps holding on. Florida disqualification rule limiting the judge to a bare determination of legal sufficiency was designed to prevent the creation of an intolerable adversarial atmosphere between the trial judge and the litigant. And this is all case law right now. In other words, all he's done in fighting the motions is he's made himself an adversary of me. I file a motion to remove him. He fights me on it. He's now an adversary. I file another motion to remove him. He fights me on it. He's now an adversary. It's very obvious that there will not ever be a fair trial with him because he's made himself an adversary, fighting and arguing the entire time. It's like a couple that just won't stop. Oh, the wife loves to poke the bear. And then the bear swipes back and the wife goes, "How dare you!" And then that whole thing, Thanksgiving, 25 years ago, comes up again. That one time that he didn't remember that she got a haircut, didn't notice, and it comes up. That's Judge Grudge. Although I noticed his haircut. Okay, well, let's keep going though. And Judge DeThomas's lengthy accusatory disqualification orders far exceeds the proper scope of inquiry for determining legal sufficiency and perpetuated. I can't even say most of these words. It's just la, 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 la. This is like reading the genealogies in the Bible. Perpetrated the intolerable adversarial atmosphere already created by the judge in court on January 23rd, 2024. A judge's antipathy, not antipathy toward a counsel for a party can serve as a basis for judicial disqualification as well. In other words, he keeps reprimanding, he keeps being adversarial against my lawyers, Mark Feather, Shockett, Doreen Ingalls. He keeps fighting with them as well. He's a judge. His job is to listen and then make a determination. His job is not to fight me. His job is not to fight my lawyers. His job's not to fight LIEnette. Although he's done nothing to fight LIEnette, he just lets her go. And that's what got us in this situation for $125,000 spent already on my side and much, much more to come. All right. Hale's second disqualification motion on February 11th addressed Judge DeThomas's inappropriate, aggressive conduct, hostile comments, and excessive participation at the January 23rd hearing, accumulating in Hale's due process rights being violated. Remember, he has not allowed due process to take place. He actually stopped the deposition of LIEnette, which is illegal. I can't even fathom. Nobody could have ever fathomed that this would be happening. It's insanity is what it is. The 2,549-word order from Judge DeThomasis on February 14th was a retaliatory against Hale's attorneys for perceived transgressions or sins concerning collateral matters going back to the very first hearing on November 29th, 2023, when attorney Mark Feather appeared in court with Hale's. Judge DeThomas's disqualification orders defend the very maltreatment which served as the basis for the motions in the first place. In other words, he did it again. That's what it means. I filed a motion. He failed to dismiss it, and that in itself is reason to dismiss. I filed another motion. He did it again. That's what it means. Regardless of whether the orders deny Hale's motions as legally insufficient constitutional error, counsel in those orders justify the judge's abusive treatment compounded by the error, thus requiring immediate disqualification. In other words, he screwed it up yet again, and he needs to remove himself. Indeed, the judge seems to be proactively answering to a higher authority, stating, to the extent of any reviewing court deems the totality and the context of actual language delivered to be relevant and material, a recording or a transcript would be available. The judge's actual language delivered is set forth in detail, and supported by the January 23rd hearing transcript, an audio-video recording. The portrait is one of oppression and vindictiveness. A judgeship is a position of trust, not of adversary. Litigants and attorneys should not be made to feel that disparity of power between themselves and the judges, which jeopardizes their right and justice. Oh my goodness. It just goes on and on and on. Commenting on the statute of record is not recognized in the district, nor did the judge do it properly. So now what we're doing is pinpointing exactly what he did wrong and illegal. In paragraph 3 of the February 28th order, Judge DeThomasis wrote this: in a ruling on legal sufficiency and a motion to disqualify, a judge may explain the status of the record. Further, a judge may comment factually on what transpired. Now, this is Judge DeThomasis fighting, being an adversary, which the law states he can't do. Now he's trying to use law to his defense, and he's not a defense attorney anymore. He's a judge. During relevant proceedings when ruling on a motion to disqualify. And what do my lawyers say? And me? I say, for such precedent, this judge cites a certain older cases from the 5th DCA, which directly conflicts with those in the 1st DCA. See Baylock, Supura, DH, Department of Children and Families, and precedent from the 1st DCA, which controls here, has never authorized any comments on the status of the record when denying a motion to disqualify for bias. However, even if it were permitted, that was not what Judge DeThomasis did in the disqualification orders. The statements directed at Hale's counsel were based on the judge's opinion, not on objective facts. Nor could they have been based on facts, because this record would reflect that Judge DeThomasis never asked or even allowed the attorneys deemed to have been committed any alleged offense an opportunity to be heard before condemning them into eternity. This is the judge that lets LIEnette and Silver Scam say anything, and my side of the aisle say nothing. All right, Judge DeThomasis created his own definitions for certain words in a rule, kept the definition to himself, and then used it punitively to belittle the attorney and deny due process of the litigant. In other words, he did not let me have a fair court case. Case in point, paragraph from the February 14th order says, Attorney Randall Shockett conducted a video deposition without complying to Florida Rule of Civil Procedure. And the court denied counsel's ability to play the video deposition, which was taken in non-compliance. What did Shockett do to cause such a reaction? The answer is this. His notice of video deposition served on Preston and Cook did not contain the name of the videographer. I want you to understand, you don't get the name of the videographer until they are actually appointed to be the videographer. You can't serve somebody with the name of the videographer when the videographer hasn't been appointed yet to the job. The videographer is appointed to the job, and then it's stated as the deposition happens. It's ridiculous. The disqualification orders are not reflective of factual commentary on what transpired during relevant proceedings, only Judge Craig DeThomasis' biases. A retaliatory ruling in a reaction to request or disqualify a judge or officer constitutes a violation of the Code of Judicial Conduct. B, the orders refute allegations in Hale's disqualification motion, despite the judge's bare contention of not passing any judgment on the truth of the facts alleged. He did. In other words, he crossed all legal boundaries. Paragraph 9 of the February 14th order states, any objective review of the proceedings held on January 23rd, 24 would not cause a reasonably prudent person to fear not receiving a fair trial. However, as such, fear rests in the mind of the litigant, not the judge. I hope you get that. He says any prudent, any normal person wouldn't fear going before me. Well, it's not him who gets to determine fear. It's me, and I fear not receiving a fair trial. Okay, it's not for the trial judge to say it's not there. A trial court cannot insert its own views regarding the facts or the motivations of the parties, but it must review the disqualification motion from the litigant's perspective. The judge's statements directly refute Hale's sworn allegations that he fears not receiving a fair trial before this judge and was therefore improperly, commentarily indicated a bias. Hale's experienced firsthand the intolerable adversarial atmosphere fomented by Judge DeThomasis, and it's Hale's perspective to be considered in court, not the judge's. The rule is clear in Florida that a judge cannot take issue with the allegations of bias or prejudice made by a party seeking to recuse him from a case. Recuse means to remove. When he does so, he becomes disqualified to continue to preside on the case. Want to know what the appellate court has to say about Judge DeThomasis? We're going to get there soon.